So we're going to have a working lunch today. Take a few minutes now, restroom break, grab some lunch. But we are going to be joined by Director Michelle Lee. I think it's going to be a really fascinating conversation, picking up on what we've already been talking about. So grab some food, come sit down, and we'll resume around 1 p.m.
You coming back tomorrow?
I'd like to introduce our keynote speaker for the lunch hour, and let me just say it's truly an honor to introduce our lunch speaker. And I joked earlier about the P-Tab as the new kids on the block. I have a big interest in the music industry, and I'm inspired by great artists. But I have to say that our lunch speaker, perhaps unlike the new kids on the block, is a true rock star in the patent world. She has put together the most remarkable training background experience of anyone in our field, and it's no coincidence that she was tapped to be the Undersecretary of Commerce and the Director of the Patent and Trademark Office. Her investment in education, in learning about technology and law, and her experience in so many different areas. I mean, it's amazing to me that she could have done all of the things that are listed here, and I do want to reference these partly because we have some students in the room and they're thinking about careers, and this is really the model. Obviously, as the head of the PTO, Director Lee, Undersecretary Lee, is seeing a broad view of one of the most important, largest institutions, and it truly is a factory. When you go over to the campus, it's a remarkable place, and there are over 12,000 employees. They are increasingly spread out. They now have offices throughout the country. There's an annual budget over $3 billion. So it's a massive undertaking. And I know from some time that I've spent there that just dealing with the day-to-day operations is a full-time job. And yet on top of that, there are all of these important policy challenges that we have been talking about. But to go back to the beginning, Michelle was she studied at MIT, earning her bachelor's and master's degree in electrical engineering and computer science. And I wonder if back then she would have imagined serving in this capacity. But I know that she went and worked as an electrical engineer and sort of saw technology really at the front lines, at the bench level. She ultimately makes her way to Stanford Law School, where she excels, and goes on to do not one, but two very IP-oriented clerkships. She clerks for Vaughn Walker, a hero of mine, because he was on the Apple and Microsoft litigation way back when in the GUI battles. And then she goes and clerks at the Federal Circuit with Judge Paul Michel. She works at Fenwick and West, which was one of, I would say, the two major founding law firms in Silicon Valley. I mean, now Silicon Valley is a center for law work, but back in sort of the early days, New York and Washington, they were the center. But now all the law firms are opening offices and using the models that places like Fenwick did. And I know she worked with David Hayes, who's one of the deans of the software advising world. And then she comes along with David Kapos, comes into the office and eventually takes over the reins. Along the way, she becomes one of the real influencers in this field. She's been identified on various lists as one of the most visionary, most influential people in our field. And last, I'll say perhaps least, but for me not least, she, along with her then colleague Suzanne Michel and some of the other sponsors who you met, they came up with the idea for this conference series, now in its 8th year. And it's those kind of investments that I think, really show the character of the person who we're going to hear from. And I have to say, I'm very much looking forward to her remarks now that we're at kind of a new era and we get the benefit of someone who has really been at the center of these discussions. Shall we?
Thank you, Peter, and good afternoon, everyone. I'm humbled, honored, embarrassed. I'm glad you talked to my mom about all the details of my background, and I'm glad you are all now familiar with it. But really, it's an honor and privilege to be with you here this afternoon. I am very proud of being here now in my current capacity. I guess it was 8 years ago when we established this conference. It's kind of back in full circle again, being here. So delighted to be here. And I'd like to focus today on a couple of topics. I think lately there's been a lot of prognosticating about what the IP policies and priorities will be in the next administration. And I will certainly spend a little bit of time looking through my crystal ball, prognosticating on that topic. But before that, I'd like to share with you my thoughts on the current state of the United States Patent and Trademark Office, and how it situates us for the opportunities and the challenges that lie ahead. So let me start with something that we all know is true, but cannot really be stressed enough, and that is IP is increasingly important to our increasingly information-based economy. And this is perhaps best illustrated in a report conducted by the USPTO in collaboration with our Department of Commerce colleagues at the Economics and Statistics Administration. And this report found that on the economic impact of IP-intensive industries, they found that IP-intensive industries supported more than 45 million jobs in 2014, or about 1/3 of all jobs in the United States. Also, these findings parallel a recently published joint study by the European Patent Office and the European Union's IP Office that found that about 38% of all employment in the EU stems from businesses that use IP rights greater than average, more than normal. So the bottom line is, whether you're in Washington or London, anywhere in between or anywhere beyond, IP remains a key driver to economic growth and prosperity. And that is why I believe that the incoming administration must and will have to focus and continue to promote innovation through a strong and robust IP system. Support for IP has always been a bipartisan issue historically, and there's no reason to imagine that with the changing of a new president and even a new Congress, that both of whom want economic growth, that IP also will not be a priority. But first, allow me to look back on what we've done during this administration and how it positions us for our work ahead. When President Obama was inaugurated in 2009, his focus was on leading the nation's recovery from a Great Recession. It was a Great Recession back then. And one of his first acts was to ask the Smithsonian to provide for display in the Oval Office some patent models that demonstrated America's past innovation and how industries were created as a result of that innovation. And the Smithsonian provided him with three patent models. Samuel Morse's telegraph from 1849, John Pier's gear cutter from 1874, and Henry Williams' steamboat paddle wheel from 1877. The president said that throughout history, Americans solved their problems through innovation, like those embodied in those three patent models. And he wanted to be reminded of America's ingenuity and innovation by having those models in the Oval Office with him when he was faced with challenges. So among the challenges that he was facing at the time he was sworn into the office was that the USPTO's patent application backlog and pendency was at an all-time high in January of 2009. Today, both our backlog and pendency numbers are lower than they've been in more than a decade, despite increases in filings, and they will continue to go down. That's hardly the only success story, but it's emblematic of how much the USPTO has charged forward during the last 8 years, and really how it situates us and positions us very well for future opportunities and challenges and addressing them successfully. And I will say that this has been a team effort, and incredible work done by my predecessors, congressional cooperation. I see a couple of congressional staffers in the audience, and the incredibly dedicated and talented team of the staff at the U.S. Patent and Trademark Office. And let me add, in addition to all the help from all of you who provide comments and feedback. So together, I think we've worked together to put the agency in a spot where it's well situated to tackle the challenges and the opportunities that lie ahead. I will say that today we are more financially secure thanks to the Americans Invents Act, a milestone of this administration, which gave us, among other things, fee-setting authority that has made a tremendous difference in terms of our work. Additionally, we are more customer service-oriented and more responsive to stakeholders than we've ever been in the past. We've constantly welcomed, in fact, solicited feedback and input and are willing to refine and improve when and where needed. We've had more requests for comments, proposed rules, and roundtables, including on such topics as our Enhanced Patent Quality Initiative, our 101 guidance, our PTAB proceedings, both implementation and refinements, and our transparency of patent ownership proposed rules. So I will say thank you for your input, thank you for your patience, and thank you for your help in responding to each of those. We've also brought a broader range of services to support American innovators where and when needed. For example, 4 regional offices located across the country in Dallas, Denver, Detroit, and the Silicon Valley, and over a dozen IP attachés across the globe. We've also worked to provide you with more access to examiner interviews, increasing the number of examiner interview hours by 232% in the last 8 years. Finally, and importantly, the USPTO's relationship with all of our partners is healthier and stronger than it's ever been in the past. That's with the public, our employees, Congress, and within the administration. And I want to take a moment to pause there to expand upon it slightly, because I really do believe that that is the key to the agency's past success as well as its future success. If you think back even just 10 years ago, our relationship with the public was nowhere near as collaborative, supportive, transparent, or productive as it is today. The agency did not often seek public input on our examiner guidance or implementation rules. In fact, if you think back 10 years ago, the USPTO was sued in Tafis v. Dudas when it decided to move ahead despite much public opposition to adopt rules that would have placed additional burdens on patent filings. And interviews were not encouraged as they are today. Together, we have changed that dynamic, and we now work together much better together. Second, we've also strengthened our working relationship with our employees. All told, we've enjoyed some of the highest rankings in the Partnership for Public Services list of best places to work in the federal government. And we all know that an engaged workforce is one that produces better quality products and better services. We have also maintained a healthy working relationship with Congress on both policy proposals as well as operational issues, from the passage of the America Invents Act to the Defend Trade Secrets Act, and also for technical assistance on various legislative proposals. We have engaged with our colleagues on the Hill in impactful ways, and I like to think that the USPTO's voice is a respected one on the Hill. Finally, the USPTO is effectively fulfilling its role as principal advisor to the President and the administration on IP policy. I've been pleased with the confidence that the President and the Secretary of Commerce has shown my team and I, allowing us to move forward with policies and programs that are really in the best interest of American innovators. All of this, the greater financial security, the customer service orientation, the better relationship with all of our partners, has enabled us to make real progress on our priorities and situates us for even greater success on our challenges and opportunities moving ahead. There's strong evidence that there's of this in a number of important areas, including our patent backlog and pendency, quality, and policy. During this administration, we have reduced the backlog of unexamined, newly filed patent applications by 30%, despite an average 4% year-over-year increase in filings. We've reduced our first action pendency by 38% to 16.2 months. And we've reduced our total pendency by 25% to 25.3 months. And importantly, the average patent term adjustment has fallen by nearly 40% since 2009, and it is now around 6 months, and that number will continue to go down going forward. Armed with greater financial resources and a shrinking backlog, we embarked upon an unprecedented effort to enhance the quality of the patents in our system, a core goal of the agency. Some of you have heard me say this before, but I truly believe it's true. There's a cost to society if the USPTO issues a patent that should not issue. Just as there's a cost to society if we don't issue a patent that should issue. And just as there's a cost to society if there's a patent that's in the system that may have been properly granted at the time of issuance, but that due to changes in case law is no longer valid. Recognizing this, we have enhanced the quality of the patents in our system, both before they leave our office through our Enhanced Patent Quality Initiative, led by a new deputy commissioner and a newly created department within the patents organization solely focused on enhancing patent quality. And after the patents return to the agency through our Patent Trial and Appeal Board proceedings and other post-grant review proceedings. Addressing the second prong first, and especially in light of the panel discussion that we had earlier, are the new PTAB proceedings, not so new anymore, actually, now 3 to 4 years old. They have significantly changed the landscape, both litigation and prosecution. We've had more than 5,000 PTAB petitions filed to date, and these proceedings have met congressional mandate to provide a faster, more cost-effective, and more efficient check on the quality of the patents in our system. With extensive input from all of our stakeholders, we've worked hard to implement and conduct these proceedings as fairly and as effectively as possible within our congressional mandate. And that's why one of the first things I did when I became the head of the agency was I asked my team to engage with all of you in a series of listening tours that led to some quick fixes in 2015, and then more substantive revisions to our rules in last April. And that's why we also took it upon ourselves to assess the frequency of motions to amend, which were mentioned in the last panel, and the reasons for their grants and denials, and to share that information with all of you. The bottom line is we are listening to you, and we are applying the input that you provide to us to identify how and where we can and should do better. With all of that said, it's essential that these post-grant review proceedings are properly calibrated so that they provide a quality check and do not bar deserving patentees from enforcing their patent rights where they need to. And it's why a number of the protections in the AIA, such as restrictions on the timing of challenges, thresholds that petitioners must meet in order to institute, and strict estoppel provisions are really critical. It's also why the agency is committed to revising our rules as many times as needed so that the proceedings are as effective and as fair as possible within our congressional mandate. It's also why it's critical within this framework that the USPTO issue the very best quality patents possible. Patents that are correct, clear, and consistently issued across our examination core. And that's why I launched the Enhanced Patent Quality Initiative in 2015, so that patent owners can have greater confidence and certainty of their rights in this new environment. Today, we have about a dozen or so initiatives underway that we believe meaningfully move the needle on improving the quality of the patents in our system. This includes making sure that we are getting the most relevant prior art before our examiners as early as possible, by making prior art cited in our PTAB proceedings available to examiners who may be examining a related child application, by transitioning all of our examiners from the decades-old antiquated US patent classification system to an updated, increasingly global cooperative patent classification system. Why am I focusing on that? Because our classification system had not been updated in decades, and we all know technology has changed significantly over the past decades. So if you want our patent examiners to find the most relevant prior art quickly, you know what? You have to update the classification system. Well, we did that. All the examiners are now onto this global classification system, and guess what? Every examiner who is participating across the globe, and there are now increasing numbers of them, they're all looking at the same places. They're all classifying their arts to the same classification system. So these examiners can get the most relevant prior art quickly and efficiently. That increases patent quality across the globe of US patents and foreign countries. So a very key piece of it. It also includes drilling down on best practices such as clarity of the record, developing new ways to measure our progress through our master review form and new quality metrics. And importantly, and this is important, reviewing the amount of time our examiners need to do their work in light of these changes and other broader changes that are occurring within our system. So this, at a high level, is what we are doing. But I'd like to drill down on some specifics on one program in particular, and that's our Clarity of the Record initiative and some of the great progress we've been making on our Clarity of the Record pilot program. The goal of this program is to develop best practices on how much detail to include in key parts of the prosecution history. For example, interview summaries, reasons for allowance, and claim interpretation. Regarding interview summaries, how many times have you reviewed a file history and saw a patent rejected or claims rejected, then saw that there was an interview, then the claims were allowed or the patent was allowed with little or no amendment to the claims and little or no explanation? In this pilot program, we work to provide more detailed summaries, including the substance of the examiner's position, details of any agreement reached, and a description of next steps following the interview. After the pilot concluded, we measured 22 data points focused on clarity and found an average of 15% improvement in clarity between the pilot and the control group. On reasons for allowance, how many times have you reviewed a file history and there was nothing in the record to indicate why the claims were allowed? Because it is at the discretion of the individual examiner to set forth reasons for allowance. Those reasons for allowance were not always included in every notice of allowance. In this pilot program, we trained our participants in setting forth reasons for allowance in every notice of allowance. At the conclusion of the pilot, we found a 25% improvement in the clarity of reasons for allowance between the pilot and the control group. On claim interpretation, how many times have you reviewed a file history where there was clearly an issue of claim interpretation, yet the record was devoid of any explanation or statement of claim interpretation? In this pilot, examiners were given training on explicitly setting forth key claim interpretations to minimize ambiguities. For example, explaining all Section 112F presumptions and whether the presumptions were overcome. Identifying on the record the structure in the specification that performs the function. And when a prior art reference is used to reject multiple claims, clearly addressing the specific limitations in each claim that provided the basis for the rejection. With our trainings on interview summaries, reasons for allowance, and claim interpretations, we saw a statistically significant improvement in clarity when examiners used our best practices. Also, if you think about it, the Clarity of the Record initiative furthers the goal of compact prosecution by encouraging the applicant to rebut the examiner's on-the-record positions promptly and directly if there is disagreement. In short, we are already taking steps to clarify the record, and you will see our examiners doing so increasingly over time. And importantly and necessarily, we are simultaneously reviewing the amount of time needed for this effort, and we will work with the public to determine the desired amount of additional clarity and the amount of time necessary to achieve this properly. Of course, patent quality also means applying the law accurately and clearly, even in areas of the law that are evolving, including, for example, the 101 jurisprudence on what is patent-eligible subject matter. As many of you know, we spent a fair amount of time and effort in recent months and years on this issue. Following major court rulings, we've revised our examination guidance with input from all of you multiple times and trained our examiners on this new guidance. And we recently announced in a Federal Register notice 2 roundtables focused exclusively on the topic of patent-eligible subject matter. At the first roundtable that was held on November 14th, we discussed potential updates to our examination guidance, public-provided input, and we asked for written comments. At the second roundtable, which is this coming Monday, so I'd encourage you to all join and participate, December 5th, we will discuss the impact of the current 101 jurisprudence on innovation and what changes might be made to better support innovation, and whether those changes are best achieved legislatively, judicially, or administratively, including through the United States Patent and Trademark Office. I thought it would be helpful to begin a public discussion to create a record of where there's agreement and disagreement, and what, if any, improvements would be helpful to make in this area. So we welcome your participation on this important and very complex topic. As I hope you can see from the quick rundown of our initiatives, we are very excited about our Enhanced Patent Quality Initiative. It is an ambitious effort, yielding some results now, with many more results to come in the long run. And to learn more about our progress to date, please join us on December 13th at the USPTO, where we will spend a good part of the day going through each of our dozen or so enhanced patent quality initiatives, discussing the results that we've achieved so far. I think you will like what you hear. We've clearly made tremendous progress over the past 8 years, but of course, we have more work to do. As I said earlier, I'm optimistic that the incoming administration will share our appreciation of the importance of intellectual property as a driver of economic growth. As I look ahead, I foresee legislative patent reform changes will continue to be discussed in Congress, though these conversations will likely occur later in the term, after some other priorities, including the filling of a Supreme Court vacancy, immigration, and tax issues are addressed. And any legislative patent reform will likely be more targeted rather than the comprehensive reform that we've seen in prior Congresses. I would hope that any legislative proposal would take into account the numerous positive changes that have already occurred in our patent ecosystem, including in the courts on the issues of attorney's fees, pleading requirements, discovery limits, and also at the USPTO through the Patent Trial and Appeal Board, and also through our efforts to improve the quality of patents in our system. As far as issues, I predict legislative discussions may include possibly changes to Section 101, PTAB, and maybe venue. Further, I anticipate the USPTO's work across the globe to ensure that other countries have strong IP protections, adequate enforcement mechanisms and remedies, and appropriate technology transfer or licensing and competition policies will continue in the next administration, particularly with regard to such countries as China. This is a president-elect that has promised economic growth and job creation, and IP will necessarily be a key piece to achieving this goal. So with that, let me conclude by saying that I firmly believe that the United States Patent and Trademark Office is healthy, well-functioning, and poised to successfully handle whatever challenges and opportunities lie ahead. Our issues are important, complex, and nuanced. And while not everyone will always agree with all that the agency does, we are well prepared and poised to work together to accomplish our shared priorities and address the challenges ahead. Now, as I stood behind the president in the Oval Office earlier this year, when he signed the Defend Trade Secrets Act, I couldn't help but notice those 3 same patent models from Morse, Peer, and Williams along the wall to my left there, still there almost 8 years later. And my hope is that the president-elect keeps those patent models there from Morse, Pure, and Williams in his office as a reminder of the importance of intellectual property to the economic prosperity that I know he wants for this country. So thank you for your attention, and I'd be glad to answer a few questions, time permitting.
Director, I wanted to ask you about, with the regional offices, could you comment on how that has changed the hiring practices, where the new examiners are coming from? Are you getting enough applying? And then how does the training work to integrate new folks when they're dispersed throughout the country?
Yeah. Thank you, David, for that question. So as many of you know, my first job in public service, aside from a judicial clerkship that I had just out of law school, was being the Silicon Valley director. And I am absolutely convinced of the merit of those regional offices for the benefit of American innovation. I mean, so much innovation occurs outside the Beltway. And the USPTO offers so many services in support of innovators, but it wasn't making it out to the far regions of this country where innovation occurs. So with the America Invents Act, we got congressional authority to go ahead and establish these offices. We very carefully chose these handful of locations located in each of the continental time zones, covering regions of the United States where there was not an office. And I'm proud to say that I've had the privilege of literally cutting the ribbon of 3 of the 4 of these regional offices, and we are hiring incredibly talented PTAB judges and examiners in all of those offices. There's a lot of technical talent outside the DC area with a lot of industry experience, and to the extent that people with that kind of background can bring it to the agency, you will see, I think, improvements and enhancements in quality of, I mean, they still have to apply the statute and the prior art, but that perspective, I think, is a very valuable perspective. And I know you're from the Texas region. I will say that I think the first examination class out of our Dallas regional office had something like 35 openings, and we had something like 400 plus applications. And by my calculation, we would have accepted something like 4% of those who applied. And that's a lower acceptance rate than Harvard has for its undergraduate admissions. So I consider it a real privilege and honor that we are able to select some really top-notch technical talent out of our regional offices. And on the PTAB judge front, it's no different. We have incredible patent litigators with incredible depth of experience, and we've hired some tremendous ones in our Dallas office, our Silicon Valley office, our Denver office, and Detroit as well. So, I mean, as far as I'm concerned, like the level of talent that the agency is getting and the benefit that those perspectives will bring to the agency is all positive, not to mention we are now in those communities. I mentioned the one-on-one roundtable, the enhanced patent quality discussions. Those are now being televised with remote participation so that even if you're a small startup company and you have an opinion about how our programs are working or not to support your innovation or not, which it will affect your innovation, it will affect your business, right? You can now participate much more easily. And we need that inclusive ability to have input from everybody. It shouldn't just be the big companies who have a legal department and a governmental affairs department who can monitor, who can provide input at the right time, at the right place, right? Everybody needs to provide input in order for us to best fulfill our mandate. Okay. Thank you.
Well, we are really on time. We're actually ahead of time, partly because we slotted a longer lunch. But what I'm going to say is we are waiting for a couple of our panelists for the final panel, which we're going to start promptly at 2 p.m. So we've got some dessert remaining, some coffee and tea, and we'll resume at 2 p.m.
Well, friends, welcome back from lunch. Let's go ahead and do our final panel of the day, which is Case Law Year in Review. I'm really happy to be moderating this panel because I've got such a distinguished cast of old friends and old friends of this conference. On the far left, we have Mark Freeman. I'm sure is known to just about everyone in the room except for the few students sitting in the back there. Now remember, every year we have to write a new patent law final, so we're always looking for new cases and for new fact. So just an idea, okay? So anyway, Mark Freeman is the Senior Appellate Counsel with the Appellate Staff of the Civil Division at the U.S. Department of Justice. which that means is he supervises most intellectual property-related appeals in which the United States or a federal agency is involved, and he also works closely with the Solicitor General's office. He's argued more than 50 appeals on behalf of the federal government, including numerous patent matters. He's appeared in all 13 federal courts of appeal, as well as the Supreme Court. He's a graduate of Harvard Law School. Next to him is Deanne Maynard. She is a well-regarded Supreme Court advocate. She's argued 13 cases before the Supreme Court, and she's argued more than 25 appeals at the federal circuit. She's also a Harvard Law grad and clerked for Justice Breyer and Justice Powell. To her right is the wild man of the panel, my old crazy friend Josh Sarnoff, who's a professor of law at DePaul University, Stanford and MIT graduate. I think Peter Manel has said frequently, every time I see it, Peter just tells me the same thing I've heard before, that Josh Sarnoff filed the brief in Alice v. CLS, which basically said the same thing as the Supreme Court opinion ultimately did. So if you think we're in a mess right now, that's the one you should direct your withering gaze toward. Josh, thanks again for joining us. To my left is Tim Holbrook, one of my academic colleagues for a long time now. I remember the first time I heard Tim speak, I think was in Portland, Oregon. I think it was at the Lewis and Clark Law School, and the power went out. And he had these beautiful slides. It was already, the power went out. And you know what? He just continued on with the talk. And so hopefully we're going to have the power on this time.
You paid the bills. Okay.
Yeah, right, exactly. I should mention that Professor Sarnoff's scholarship, I think he writes on a lot of things, but I think Section 101 is obviously one of his areas of focus. Tim also has a wide array in his scholarly portfolio. I think the work I admire the most is on the international, multinational, and comparative stuff, and we've asked him to speak in that area. He clerked for Chief Judge Archer, and I also admire his continued commitment to advance the rights of the LBGT community. All right, so with all that said, I'm going to ask Tim to go first and talk about some of the cases over the last year on the statutory bars.
Sure. It's great to be here. I'm really happy to be able to attend. This throws me back to my very first law review article ever talking about the on-sale bar. So I'm going to look back a little bit at the 1952 Patent Act and look forward at the AIA, right? So this past year, the Federal Circuit decided the Medicines Company versus Hospira case in Bank, talking about the on-sale bar. In that case, there was basically an agreement between the patent owner and the supplier to provide this particular drug. It was a product by process claim, and they supplied that pre-critical date. There were some other distribution agreements at stake, and the panel had concluded that that triggered the on-sale bar, that there is no supplier exception. And so the court granted in bank review to talk about whether there was a sale under these circumstances for purposes of the 102 bar, and whether this was an experimental transaction instead, which they ultimately don't reach because they conclude that this was simply not a commercial offer under the first prong of FAV. And then they asked, should they overrule or revise special devices, which is where we have the holding that there is no supplier exception. And so ultimately here, the court gets a little more nuanced, right? They don't really expressly overrule special devices. They sort of do. They say to the extent it's inconsistent with this case, those earlier cases are overruled, but they don't adopt a bright line rule one way or the other. They really just say in this case, these circumstances don't trigger the bar. There was no transfer of title in this circumstances. All that was sold were manufacturing services, not the invention itself. The inventor maintained control of the invention, and stockpiling standing alone is not going to trigger the on-sale bar. And so that's what the in-bank court did. It's interesting to me that all the panelists joined, right? So maybe they felt bound by earlier precedent and were happy to end up losing, but that is a rare scenario in bank. And it's also interesting that the court does confirm in dicta that secret sales can be invalidating under the 1952 Patent Act. Now, why is that important? Because of the Helson versus Dr. Reddy's case from the District of New Jersey back in March, which is the first case interpreting the new prior art provisions of the American Invents Act. And there had been this ongoing debate debate about whether the AIA actually changed the case law, right? As we know, 102A keeps the 102B language of whether it's part of printed publication, on sale, public use, but adds this fifth category of otherwise available to the public. And so already amongst academics, there's been this debate. Is the law the same, or has it changed dramatically, right? And here, the district court addressing the on-sale bar aspect of the new AIA concluded that, yes, the law is different, that in fact, secret sales no longer trigger the on-sale bar, or under the AIA, no longer constitute prior art because they're not publicly available. They relied on statutory interpretation, right? They looked at that language of otherwise available to the public. Otherwise suggests that the preceding four categories also must be available to the public, so that suggests a public accessibility concern. They looked at the USPTO guidelines, recognizing that those were non-binding, but the PTO had suggested that the AIA did change this line of cases. Also lurking in the background here, of course, is the metallizing line of cases, the public use dynamic, although this was technically an on-sale bar case. And interestingly enough, they addressed public policy, and they said, look, the first-to-file system created a problem of abuse that absent the statutory bars, the first-to-invent system created opportunity for abuse. Absent the statutory bars, I could sit on my invention for a while, commercialize it, and when I see other people practicing the invention, then go ahead and file, and because I was first to invent, I'd be protected. That policy concern is no longer present under the AIA's first inventor to file regime because you really are time limited and you can't wait for somebody else so much because they can beat you in the race to the patent office. So they suggested that policy consideration supported changing this posture of the law. Now, I'm not in that camp. I disagree with the district court. I think when you say on sale and public use in one statute and you import it into a new statute, it says the same thing. I don't find the legislative history to be that terribly strong.
The same thing plus some new language, you mean?
Yeah. I mean, I don't think the new language does that. To me, the new language is sort of a fifth category, not informing. But this is on appeal to the Federal Circuit, unsurprisingly. We'll see what they have to say. And so we have definitely had some significant movement in both the 1952 on-sale bar and then interpretation of the American Invents Act's prior art provision of on-sale.
So, of course, the rule of the last antecedent is the key question there, right? Who ever heard of that?
I guess so. I mean, agency action is set aside if it's arbitrary, capricious, or otherwise contrary to law. So I'm sure in that context, nobody thinks that otherwise contrary, that arbitrary and capricious are not also subsets of contrary to law. So I think the otherwise doesn't work there, but we'll see.
Well, my other concern is that, so what counts then, right? And even the old public use cases said one public use was enough, one sale could be enough. So now only commercial transactions that are in some sense very public, very commercial in a broad sense, not one-on-one transactions count. I think there's a lot of one-on-one transactions that take place, which we should be concerned about from a policy perspective if we think this is any good or not. But I think you now cut out a huge swath of prior art, and whether that was the intent of Congress, given that verbiage, would be, to me, a challenge given the antecedent interpretations of the 52 Act.
Perfect. Well, let's move along then. And Josh, can I ask you to bring your mic a little closer?
sure.
Usually listening to you or hearing you isn't a problem, but it might be this time.
Okay.
So I had a seminar with 22 students, and 5 of them spoke on Section 101 over the last month. So I've heard a lot on Section 101, but now I'm sure this is going to be the best one. Please proceed.
So I have to try to help you make sense of this mess. I'll say a few things. First, it was a good year for patent holders because, as you'll hear in a second, the various cases coming out of the Federal Circuit essentially identified 5 different levers that could help you to get to patent eligibility. The concern, of course, therefore, is that as the Patent Office follows the case law, it's changing the standards, so presumably claims that should have been allowed if the new case law is in fact right, which we'll never know, have been disallowed. Maybe those claims are still pending in applications and can be resurrected, but it's just a mess. Going back to Director Lee's comments, legislative fix is one possibility. It'll be very difficult. I do recommend that you look at the Judge Archer dissent in Allapat about what kind of line drawing is required in order to get meaningful legislation. The judicial realm has proved unwilling or unable so far to provide the clarity we need. So I'm actually hoping the PTO can get out in front of this rather than following the courts and do some good. Let me start with just very quick review of the Supreme Court troika, because it'll help to explain the other cases. Mayo in 2012 discovered an induced human metabolic correlation with synthetic drug as an ineligible law of nature, identifying a much broader category than people had thought. It adopted a two-step test for determining when claims applying such a correlation are eligible, using the language that a claim process describes or recites a law of nature. Then you ask whether the claim adds enough to qualify as patent-eligible process that apply natural laws. In that case, it addressed a therapeutic claim, but it didn't require the actual adjustment of dosage and found the claim ineligible. And unfortunately, had they in fact read my brief, they would not have conflated the inventive concept or inventive application analysis with preemption concerns, while holding that the scope of a law of nature doesn't matter. So I'd like to take the credit that Peter is offering. I don't think it's justified.
I thought he was offering blame. Was he offering credit?
Maybe both. In any event, I also wanted to again thank both Peter and Jay for inviting me in the conference for holding. It's been terrific so far. Alice very quickly refined the Mayo two-step. So now the claim must be directed to ineligible subject matter. And it also clarified that an inventive concept is an element or combination of elements that's sufficient to ensure that the patent in practice amounts to significantly more than a patent on the ineligible concept itself. There it addressed the next category of abstract idea. There it was intermediated settlement. It held that generic computer implementation of an abstract idea is not an inventive concept. It required analysis of claim limitations in Mayo's, adding enough both separately and in ordered combination. And it distinguished Deere based on improving rather than using technology, creating what may be a technological test, which many people think was their effort to try to resurrect the 5-person majority that should have issued in Bilski that limited the scope of the patent system to the technological arts. Finally, and importantly, it treated method and system claims identically, even though dealing with the abstract idea category, because the claim structures were generic and performed conventional computer functions. I'll just mention in 2013, in the intervening year, in Myriad, the court adopted an entirely different standard for eligibility of products derived from natural phenomenon, the third category of eligible subject matter, based on Chakrabarty, which is new with markedly different characteristics from any found in nature. Held that isolating DNA is not an active invention. It held that producing cDNA is new and eligible without addressing whether it had markedly different characteristics. This is not very helpful. Okay, so where are we this year? First, we get the dog that didn't bark, Ariosa Diagnostics versus Sequenom. When cert was denied this year, it claimed a method of using cell-free fetal DNA for genetic diagnosis, revolutionizing prenatal care. Obviously, what you have there is a discovery or product of nature, as well as it's a natural, the process or characteristics of it could be called a law of nature. The Court of Appeals held invalidity under 101 was compelled by Mayo, treating it as a method claim and treating it subject to Mayo analysis, even though it was clearly a valuable advance and the Supreme Court denied cert. The Supreme Court there could have addressed the critical issue of whether eligibility requires an inventive application or inventive concept in light of the discovery or in light of the prior art without or before the discovery, which is really the critical issue, according to me at least, which of course the Supreme Court doesn't listen to. Okay. That brings us to the war in the trenches of the Court of Appeals, and there are so many cases here. I'm going to focus on roughly 7. If I get time, Jay will cut me off, and that's fine. The important thing is 5 were found eligible, 2 were found not eligible, and there was a split panel on one of each of those cases. But the cases, if you look at them, identify, as I said, 5 different levers that you now have to look at to analyze how one is going to assess eligibility. The first one is at step 1, how do we decide whether or not a claim is directed to an eligible subject matter? The second is the level of generality of that particularly abstract idea. The third is whether or not there's technological character, either at step 1 for that abstract idea or at step 2 for the sufficiency as an inventive concept. The fourth is whether claim construction can provide the technical character or not, even if there's facially non-technical language of the limitations. And finally, the relevance or not of preemption at step 1 or step 2. Having just said that, is it any wonder that this is a mess, right? No. So let's just quickly go through the cases as far as I can get before I get cut off. Enfish versus Microsoft, May 12, Judge Hughes, 4 judges, Taranto and Moore, writes, in regard to claims of self-referential logical models for a database using a single table for data, basically you put the data in and you define the columns by information in the rows. It allows for easier configuration and more compact data storage. The district court held all claims of both patents directed to ineligible subject matter and the abstract idea. An example claim was to data storage and retrieval system for computer memory comprising means for configuring said memory according to a logical table, including a plurality of logical rows, a plurality of logical columns, and means for indexing data storage in said table. Again, the district court concluded the means for configuring language to require a four-step algorithm, created a logical table, assign rows and columns, identify an object ID number, and store information in each, about each column in the rows, and store and access the data in cells. Okay, so how does the court now does it analysis? It reads Mayo and Ellis step 1 as requiring that the directed to analysis at step 1 not to merely involve patent eligible concepts, but whether the claim as a whole would have a character directed to excluded subject matter. And you do that by looking to the focus of the claimed advance over the prior art, citing to genetic text versus Muriel, another case decided this year dealing with methods of detecting coding regions of DNA by amplifying detecting linked non-coding regions, in which Judge Dyke for Prost and Taranto affirmed 101 invalidity under step 1. It was directed to a law of nature, the relationship between coding and non-coding regions. And for step 2, the claim cannot rely on the novelty of that discovery for an inventive concept necessary for patent eligibility. Again, that seems to go back to the question of inventive concept in light of or before the discovery, right? It also elevated at least the relatively specific technological improvements in computing or software programming as not being abstract ideas. It extends Alice's analysis of certain technological improvements, providing an inventive concept from step 2 to step 1. Thus, the court states, quote, some improvements in computer-related technology, when appropriate claimed, are undoubtedly not abstract, which includes software as well as hardware. And then it asks whether the claims are directed to an improvement in computer functionality versus being directed to an abstract idea. So now we can say, it's not just the idea of the result or the computation that you're trying to achieve. The question is this kind of computer functionality no longer an abstract idea, but technical itself at step 1, and then you don't have to go to step 2. Again, this also raises a level of generality problem. Is it the abstract idea of storing information as tables, as the district court said, storing, organizing, or retrieving memory in a logic table, or organizing information using tabular formats, versus the non-abstract idea of self-referential databases, but describing the claims at such a high level of abstraction and untethered from the language of the claims, all but ensures that the exceptions to Section 101 swallow the rule. So again, the court's going to look at the level of abstraction and define it by reference to the claim limitations to make it much more narrow and therefore, in theory, technical and not an abstract idea at all. They rejected the arguments that because it could be run on any general purpose computer, it should be ineligible because it's not directed to an abstract idea in the first place. And then, of course, yesterday, the CAFC, Judge Taranto for Judges Laurie and Moore, affirmed a IPR board decision ruling many of the claims obvious and rejecting challenges to other claims. Interestingly enough, they referred the review of they refused to review at the board many of the claims under that means for standard as not amenable to construction, even though the district court had actually found and the Court of Appeals had upheld that the same means for language was not indefinite. Okay, That brings us to McRow, which was decided on September 13th. Judge Reyna for Judges Taranto and Stoll claims to automatically animated lip syncing. I won't go through the details. Relying on ENFISH, Judge Reyna holds that the claims were not directed to an abstract idea at step one, but to a technological improvement over manual 3D animation techniques, focusing on the idea that the claim rules must have specific characteristics and must be applied to each subsequence of time phonemes. So it distinguished it from merely automating prior art animation with a computer. The automation goes beyond merely organizing existing information in a new form or carrying out a fundamental economic practices, distinguishing a 2014 case, Digitech. And he noted that the defendants didn't dispute that the processes that automate human tasks are patent eligible if properly claimed, but focused here on covering all rules and thus preempting the idea of automating lip syncing. So therefore, this decision emphasizes preemption rather than tangibility and says that it's relevant in determining eligibility at step one, then holds that there's no preemption because alternative rules for lip synchronization can be developed. So we now have yet another lever to be used to try to find eligibility at step one. That leads us to Bascom Global Tech, Internet Services versus AT&T from June 27th, Judge Chen for Judge O'Malley and Newman. Judge Newman concurred in the result to indicate that we should try to avoid separating eligibility from patentability so that we don't waste time in retrial. Judge Chen was addressing claims for internet filtering by associating individual users with specific user-identified website filtering criteria on an ISP. So basically, rather than using your own computer to filter, you can use the ISP and have the ISP link it to your individual filtering preferences, and you can have different kinds of filtering schemes. The district court had dismissed all claims as ineligible as directed to the idea of filtering content and doing so on the internet, and it's not different from doing that with books and other things, and lacking an inventive concept because each of the steps was conventional, generic computer component, or standard filtering. Notes per ENFISH that there may be close calls about how to characterize what the claims are directed to, but then says that an analysis of whether there are arguably concrete improvements in the recited computer technology could take place under step two, and then it might become clear that the specific improvements in the recited computer technology go beyond well understood routine and conventional activities under Ellis. Therefore, they didn't really address what is the abstract idea under step one in terms of a technological character, but just move that inquiry into step two. There, they held that the filtering contact is an abstract idea and is well-known method of organizing human behavior, and they rejected at step one arguments that it was directed to the narrower and more specific problems, such as filtering on the internet or making user-level customization administrable, and they held that the ordered combination of generic computer, network, and internet components was an inventive concept under step two. They emphasized that preemption is relevant in determining eligibility at step two. Quote, nor do the claims preempt all ways of filtering content on the internet. Rather, they recite a specific discrete implementation of the abstract idea of filtering content.
All right, Josh, the moment of cutoff has come. But
I didn't get to any of the ones which, went the other way, but that's fine. Anybody can ask me later.
other comments from the panelists?
Well, I think one interesting question is when will the Supreme Court weigh in again? How long are they going to let this development go on? I've been predicting for years they were going to stop, and they didn't. So maybe they've stopped now. I don't know.
I think Arioso was the case to take, and most people thought so. They showed no inclination. They've already done one under each of the categories, and I think we're going to face a continuing mess for an awfully long time. Besides which, when they've dealt with it, they've done an abysmal job. I'll just mention in myriad because I can't let it go. Within 3 paragraphs, they say that isolated DNA is a product of nature and that it's also undoubtedly the result of human intervention. That just, 9 clerks at least should have said this is not consistent on the most important issue in the case.
Yeah, I don't see the Supreme Court taking anything anytime soon. They're going to let Federal Circuit hash it out. The better and harder question is whether the Federal Circuit will sit in bank, and I actually don't think they will. They don't want to repeat Alice. They don't want to sit in bank and embarrass themselves. I think they want to get a few more. I think the term of art these days is guideposts, right? And so I think they want to see if they can, any of these guideposts coalesce into something that's a little bit more guidance, and maybe at that point they step in bank. But I would be surprised if we see any clarity in this from the judiciary in the next 2 or 3 years.
If they go in bank, then that will be the case that goes cert. I mean, because otherwise, you've got the Federal Circuit and banks setting the rule on this question, and they will not, unlike Medco, will not be a unanimous decision. And one side or the other will petition for cert. That I think would be the case that they take.
The one thing that would give me hope is the PTO through the board in an adjudication could adopt clear rules for how this should all work. Then it goes to the Federal Circuit, and that might get review.
Do you think you would say that the PTO gets deference in that circumstance?
I do.
What do you say?
But
Take
that's
a-
only
take a
for my-
wild guess.
That's for my administrative law exam.
And I do not. So.
Okay, Mark, could you continue our discussion? How muddled and mistaken was Clear Correct versus ITC?
Oh, wow. Well, first, thank you for inviting me to talk here today. I'm required to give this little disclosure. I'm here sort of as a government attorney, but expressing opinions that are my own. It is entirely possible the Solicitor General will file a brief tomorrow saying exactly the opposite of whatever I say today. So take this as only my views and not the views of the government. Clear Correct, for those who don't know it, was an ITC case, and it was a fascinating case. It's been described as the question of whether you can have digital articles. I actually think that's sort of an overbroad description of the question presented for the reasons I'll discuss. But as people know, just as background, Section 337 of the Tariff Act of 1930, the Smoot-Hawley Act, if anyone remembers the debate between Al Gore and what was his name? The vice president, Ross Perot. Al Gore held up a picture of Smoot and Hawley. Anyway, okay, obscure.
No one remembers that.
No one remembers this.
What planet was this?
This is real life. This was a presidential election years ago. In any case, Section 337 allows the ITC to exclude, as relevant here, exclude from the United States, quote, articles that infringe a valid and enforceable United States patent. So we've had a series of cases about what constitutes a theory of infringement that the ITC can act upon, and in this case, what constitutes an article that is the subject of this exclusion scheme. So in Clear Correct, you'll see why the issue is fascinating. We had a guy so the patent owner is a company called Align Technologies, and they own patents on methods for correcting teeth, right? Instead of braces, they use a series of 3D models of the patient's teeth to sort of slowly push the teeth in the right direction. So the founder of the company leaves Align Technologies, starts his own company in Pakistan making competing cheaper versions of the same models, and imports them into the United States. Physical molds, dental molds. The Align files an ITC action to exclude them from the United States, and the ITC enters a consent order and barring the importation of these physical molds. So Mr. Founder says, wait, I have a great idea. He starts a new company called Clear Correct and has a Clear Correct US and a Clear Correct Pakistan. Clear Correct US scans the patient's teeth, uploads the data to a server. Clear Correct Pakistan downloads that data, creates 3D printable models of each of the seriatim dental molds, the same things that they are or the owner is under a consent decree not to physically import into the United States, re-uploads that to the server, and then Clear Correct United States downloads them and 3D prints them. And so we go back to the ITC, and the ITC says, yes, this is infringement, and issues a cease and desist order against the two Clear Correct companies. Goes an appeal to the Federal Circuit. The Federal Circuit, in a 2-1 decision by Chief Judge Prost, joined by Judge O'Malley, holds that that's improper, and that is a plain language matter. The word article under Section 337 is a material thing, and so digital articles are excluded. Judge Newman dissents. Maybe what was in Jay's question is the United States filed 2 extensions of time. Well, first, the ITC sought rehearing. That was denied. The United States filed 2 extension applications for time to file a petition for writ of certiorari, but ultimately did not file one. So I think there are a couple of interesting things about this case. I mean, one is it's just I think that the tip of the iceberg about U.S. law interacting with the challenges posed by 3D printing technologies. In our office at the Department of Justice, we've seen this not just in IP law. I see them on. But we've seen this in, export restriction cases, firearms regulations cases, a whole bunch of cases where just the framework around U.S. law it wasn't built to originally with anyone's understanding that you could sort of email a physical device. I also think there's some interesting methodological questions here. The majority's decision sort of proceeds by asking whether any definition of article contemporaneous to the enactment of the Tariff Act of 1930 referred to digital products. You go, well, that would have been pretty extraordinary if they had, right? I mean, give that guy a Nobel Prize. And so I didn't think the analysis was all that robust, but it was still admittedly a hard case. Judge O'Malley had a concurrence where normally I think these, her concurrence was a Chevron step zero, quote unquote Chevron step zero analysis, which is basically, is this a question of the kind Congress intended the agency to speak to with authority? So it's before you even get to step one, does the statute control? You get the sort of like, is this even a thing that the agency is supposed to be doing? And she would have said no. In an odd way, I understand that way of thinking without saying whether I agree with it or not. I understand that because you think this is just it's not a problem that anyone thought that the ITC statute addressed. But on the other hand, one can understand from the ITC's perspective, I mean, what is the relevance of the agency prospectively if for a lot of products of the type, like in this very case, right, the very same dental molds were legitimately excluded. So how do we deal with a world in which you can bypass the ITC so easily? And the last thing I'll just say is there was a sort of hidden statutory interpretation question in the case. The theory of liability, of infringement liability, on which the commission ruled, there were two. One of them was 337A1B2, which is the ITC equivalent of 271G, which basically means importing into the United States a product that was manufactured overseas pursuant to a process that is patented in the United States. And here they said the dental mold was manufactured overseas pursuant to a process, the digital manufacturing process patented in the aligned patents. But the other theory is interesting. It was 271C. And they said, an article, a material adapted for use in a patented invention. The actual quote in 271C is a material or apparatus for use. And so in order to find liability there, then the digital mold not only had to be an article, it also had to be a material or apparatus. So yet another way in which just the law wasn't sort of adapted to deal with this subject.
And I don't suppose you're going to tell us why you didn't petition for cert.
Yeah, well, the reason is, no, I'm not going to tell you that.
I will say that I think I agree with you that there's a lot of pressing issues about the way these CAD files and 3D printing are going to impact patent law in a way that sort of digital files impacted copyright law. And as I've written, I don't think patent law is actually as well adapted as copyright law was to deal with it, right? And so it is something to consider. There's a number of theories floating out there that I proffered one. Some have thought, well, maybe people should be drafting claims that are specific to CAD files because those digital files really are the linchpin for regulation here. But that is clearly an ongoing question. As 3D and additive technologies evolve, it's going to create more and more pressure on the patent system. Counter argument is that it dramatically reduces costs for innovation, right? And so in some sense, maybe we aren't as worried about it because the need to recoup those sunk costs are less because it's easier to innovate using these additive technologies. Yeah,
actually, just to that, you reminded me, there's one other interesting tension in the case is between the idea of a digital article and the principle that I don't think anyone really disputes, at least in the modern era, going back to the Section 101 commentary of In Re Knighton, which is the case that held that digital signals qua signals are not patent eligible. And so it couldn't, in some sense, I think that you feel like no, but in another sense, you think if we had a business in the United States where I was inducing Josh to infringe a patent by sending him digital models over the internet and instructing him how to print them in a manner that infringes the patent, no district court would have a problem with the fact that the manner of my inducement involved the use of digital signals. So again, I think it's an interesting problem, and another one of the tensions in the law here.
And we also have the Microsoft Golden Master issue of information, and it really does raise the difficult line drawing question again between what's the difference between information and functional ideas that can then be patented.
Dan, why don't you switch our conversation and talk about venue and TC Heartland?
So for those of you who are litigators in the audience, either bringing suits or defending suits or companies defending suits, this case is of great importance to where you might be able to bring them. TC Heartland, if the court were to take cert, could have a great effect on venue. So there's a cert petition pending. It's going to be considered by the Supreme Court at their conference on December the 9th. And it basically traces the history of the venue statutes and the case law about it and argues that the Federal Circuit's currently got it wrong. So the patent statute, as I'm sure most of you know, is 28 U.S.C. Section 1400B, and it provides that patent infringement actions, quote, may be brought in the judicial district where the defendant resides. And in 1957, in Forco Glass Company, the Supreme Court held that Section 1400B governs the venue and patent infringement suits to the exclusion of the general venue statute, and that you didn't look to the general venue statute, which is in 28 U.S.C. 1391, as a gloss on 1400. And you don't supplement, what it means to be residing somewhere by looking at 1391, specifically 1391C. Since Forco, though, since the Supreme Court's decision, Congress has amended 1391C twice. They have not amended the relevant language in 1400B, but they have amended the general venue statute. And that's where the wrinkle comes in. So in 1988, Congress added the phrase to the beginning of 1391C, for purposes of venue under this chapter. And this chapter would be Title 28, which is where the 1400 provision about patent venue is. And so given that change, and on the basis of that change, the Federal Circuit concluded that Forco no longer governed, and that it could decide the case anew, or the issue anew, because there had been a statutory change. So it looked to that new language in 1391C and said, well, for purposes of this chapter, and 1400 is in 28, and so now you do read, the Federal Circuit concluded in a case called V.E. Holding, you do read the phrase, the judicial district where the defendant resides, as including any district where there would be personal jurisdiction over the corporate defendant, which is the language in 1391C. So, and they did that, the change that in the change that happened in 1988 was to move from the end of 1391C, the words for venue purposes, it used to be at the end of 1391C, and it just said for venue purposes. So it didn't say under this chapter. So now it starts out under this chapter, or it did in 1988. Okay, so the cert petition claims that after that decision in V.E. Holding, enormous forum shopping occurred. And I think probably most people would agree that many patent cases are filed in a single district, the Eastern District of Texas. According to the petition, 43% of the patent cases filed in 2015 were filed in the Eastern District of Texas. So the statute is amended again, not 1400, but the general venue statute is amended in 2011 again. This time, adding at the beginning of the general venue statute, so in 1391A, the words, except as otherwise provided by law. This section shall govern the venue of all civil actions. And it changed the introduction to 1391C from, for purposes of venue under this chapter, to, for all venue purposes. So now you have 1391C that starts out, except as otherwise provided by law, this is the general venue statute, and 1391C no longer says under this chapter. That's where this case came in. TC Heartland moved to get its case out of the District of Delaware on the grounds that there was no venue there, because this change in the statute changed the basis for V.E. Holding, and that we should be back in the Forco world, where 1400 is the patent venue statute. 1391A says, except as otherwise provided. 1400 is a more specific provision that otherwise provides, and therefore the broader language of 1391C is not applicable. The Federal Circuit, on appeal and a writ of mandamus from the denial of the motion to transfer, held no, that the VE holding was still good law, that the effect of the except as otherwise provided by law did not have the effect that T.C. Hartland claimed. And that's how we ended up in the cert petition. So T.C. Hartland has the cert petition pending. There's an opposition filed. There's many amicus briefs filed. There are half a dozen or more supporting the cert petition, and a response saying, no, the Federal Circuit's got it right. And it's on conference December 9th. And so it'll be interesting to see what they do. We should find out soon. Unless they ask for your views, in which case it'll be longer. No, not because Marcus.
I understand what you mean. I mean, one interesting thing about the 2011 statutory change, just as an observation about facts in the world, is that I think, and correct me if I'm wrong, but I think that venue change was made by the same House Judiciary Committee that was doing the AIA at the very same time. So you could draw one inference or another from that. There is no venue provision in the AIA. On the other hand, the same people at the same time added the language that Deanne discussed.
And one of the arguments in the petition is, the language that the Federal Circuit relied on, the 1988 change, where they moved the words for venue purposes at the end, which was in 1391C when the Supreme Court decided Forco, and moved it to the front and said, for purposes of venue under this chapter, the legislative history, the petitioner says, was simply, ministerial, not meant to be substantive change. But then the Federal Circuit concluded that it essentially overruled Forco.
I mean, one other oddity about the case is that it's on petition for writ of mandamus. That's odd, right? Because think about it, what it's saying is, petition for a writ of mandamus, I had a clear and indisputable right to relief from controlling circuit precedent. I mean, normally, if someone files a mandamus petition against the government, and people do this all the time, I would say, we have clear and controlling circuit precedent, therefore you do not have a clear and indisputable right to relief. So it may be that the vehicle, the actual just vehicle for this challenge is the wrong one procedurally.
However, I mean, I'm not involved in this case, but the opposite side to Mark's point would just be, without taking the position, but just to put it out there for devil's advocacy, which is the opposite side of that point is the Federal Circuit reached it on that ground, decided it on the ground, didn't say that isn't a basis not to decide it. So they did decide it. And if you took your logic to its end, almost nobody would ever be entitled to a writ of mandamus anytime there was an arguably controlling precedent. Because the petitioner's point is the statute changed the law, so there is no controlling precedent.
Right, but then I think what you would say is you file a motion to dismiss under Rule 12 for an inappropriate venue, and then if you want to, add that to your appellate issues at the end of the appeal.
After you have to suffer through a trial on what you think is like the wrong venue. I mean, that's why you get a writ of mandamus in a venue.
That's why you can try a writ of mandamus. Right. I agree.
Right, but all you have to say is that circuit precedent is clearly wrong, so.
Yeah, legislative proposals to reform the situation are really quite gruesome. They would divide classes of plaintiffs and in different, universities would get different venue proposals, small entities would get different ones, larger companies, and quite frankly, a lot of that would shift venue to Delaware, quite frankly. If you think we're going to get away from having a super district, it would probably just move.
Right.
But we'll see what comes. Huh?
That's one of the biggest criticisms I've heard of TC venue. It's like, it's not going to solve the problem of having one district. It's just going to switch the district, which I understand some people would prefer. But
And what's also interesting, if you look back, a lot of the early criticisms of the Federal Circuit is that we have put specialization at the wrong level, which should have been at the trial court level. Well, now we do effectively have some level of specialization at the trial court level, and people are objecting that it's forum shopping and bad, right? So it's interesting the way that the C's often change in this discourse.
One of the interesting things about the cert petition, I thought, just as like a good read, was that it talks about, in its policy ramifications point, this forum shopping, and goes so far as to say that, and to quote, judges suggesting that, they're plaintiff-friendly, in order to, it means the suggestion in the petition, I'm not going to attribute that to any judge, but the suggestion in the petition is that judges are saying they've made their forums plaintiff-friendly to, benefit their fora.
Okay, our next topic is going to deal with the first sale doctrine. Exhaustion is probably something you're feeling about this time in the afternoon after lunch. We're going to do it on the international level, which gives me a cue to introduce someone who's just joined us, our academic colleague from across town. Dimitri Karstedt is here. Thanks a lot. He's his second year teaching at GW in the patent area. You can tell he's only been at it 2 years and is still an assistant professor because he came after the free lunch rather than before. But experience will teach you about academic life, Dimitri, and we're hoping to learn from Professor Holbrook his impressions of Lexmark.
Exactly. But I hope everyone caught the pun, right? Lexmark versus impressions. That's the name of the case. We're back with patent exhaustion. It is exhausting. Lots of puns to be had. And we're back with printer cartridges, right? Which really just seem to drive international and domestic exhaustion cases at the Federal Circuit. This go round, you have Lexmark selling these printer cartridges. Some were sold overseas by Lexmark, so that triggers the interest of whether this is a foreign sales exhaust or count as a first sale for the purposes of a U.S. patent. They also sold cartridges under this return program cartridge where they discounted the cost of the cartridge, but there was a single-use, no resale restriction, and there was a chip on the cartridge that prohibited or blocked any ability to refill it. And so if you bought it at a discount, you could send it back to Lexmark, but you could only use it once. And so there's some distribution channels. Some went directly to end users, some went to resellers. It's not quite as relevant. If you really need, if you're suffering from insomnia, read this decision, right? It is like 100 pages long. And so I'm really doing the bare minimum because there were two issues. And of course, the accused infringer acquired some of the cartridges to resell, some were overseas, and they obtained some of these cartridges under the return program cartridge from a third party who had actually hacked the chip and allowed the cartridge to be refilled, right? So those are the two dynamics at play here. And the in-bank court first had to address whether patent law has a domestic or international exhaustion regime, right? And basically was driving this. The law had been clear that patent law was a domestic exhaustion regime, but the Supreme Court, in a copyright context, had decided the Kurtzang case. And in Kurtzang, the Supreme Court adopted an international exhaustion regime for copyright, right? So if I buy a copy of my Harry Potter book in Hungary, then that exhausts the U.S. copyright, right? And so it doesn't matter where the purchase is. So the question was, does Kurtzang dictate that the patent system should also be an international exhaustion regime? And the Federal Circuit in bank said no. So they kept the domestic exhaustion regime. They rejected the argument, the sort of in-between argument that the government had argued, right, that there should be presumptively international exhaustion unless the patent owner effectively has stated in writing that they're retaining their U.S. rights. They said, nope, the foreign sales have nothing to do with U.S. patents. They anchored it in Section 271A, actually, because unlike the Copyright Act, there's really not statutory anchors for first sale doctrine, right? Copyright is statutory. U.S. there isn't. It's all common law. So they sort of tied it to 271A and the idea that infringement is by unauthorized uses, and therefore first sale is triggered because these are authorized uses in this context. But 271A has strict territorial limits, and so these overseas sales were not authorized. Goes into much more depth than that, but we'll leave it at that. The second issue then was whether these use restrictions were legitimate or not. Mallinckrodt has been a long-standing case of the Federal Circuit saying these sort of single-use restrictions that don't violate antitrust laws are fine. Quanta at the Supreme Court threw a lot of that into doubt as to whether it survives. Quanta is an odd case. I also think that Monsanto, the Supreme Court thought they were going to address this issue. If you read the oral argument transcript, they're sort of asking Seth Waxman, like, should we decide this or not, right? I mean, it's almost like, do we need to talk about this, should we? And he's like, no, you don't need to talk about that to answer the case. So the Federal Circuit, again, I think in tension with Quanta, says, no, these sort of use restrictions are okay, and that precludes exhaustion. Therefore, all of these reconstituted cartridges are actually infringing cartridges. And so the petition for certiorari has been filed. The Solicitor General's views were received. The SG said, take the case and take both issues. The conference was originally scheduled for last week, and they delayed it until tomorrow, which is another strong signal that this is going to go to the Supreme Court. And of course, it will on both issues, because you've got two Supreme Court cases sitting out there that the Federal Circuit is arguably thumbed its nose at, even though I actually agree with the Federal Circuit on both of these issues. And so there's, in my mind, no doubt that both issues will be granted cert. Again, the conference is tomorrow.
Well, all of that is correct in the description of how it went. I just think there's a couple of interesting nuances there. One thing, a sort of linchpin of the analysis by the majority, Judge Toronto, for the en banc majority, was the conclusion that a licensee, in his view, could sell, citing the General Talking Pictures case from the 1920s, that a licensee could sell, of the patentee, could sell a product with use restrictions attached. Or put differently, the patentee could say, okay, licensee, you can sell this thing, but only if you limit it to a single use. And that the court thought that it was unquestioned that that sort of two-step use limitation would be lawful, and so they said, well, I don't understand why why it wouldn't be lawful for the licensee, for the patent owner to impose the same restriction through direct sale, or directly again on the seller or the purchaser. And one of the things the government's brief in response to the invitation from the Supreme Court says is, no, that's just not true. General Talking Pictures was a case where there was no license at all to sell for the use in question. What the patentee can do is either sell whenever, can choose, obviously a patentee can choose what sales to make, and a patentee can choose in the same way when to authorize a licensee to make a sale. But once the sale is done and title is transferred, then patent law has nothing further to say about how the article may be, used or resold in commerce. I think that that's just obviously correct, but I am biased here. But I think that will be one of the features of the conversation. I was laughing when you were discussing Quanta because in the Quanta case, the government filed an amicus brief. The line attorney in the divisions on the case was me. The assistant to the Solicitor General on the case was Deanne. And we did say we thought Mallinckrodt was terrible and should be overruled, and they did not take us up on that.
Yeah. Again, I just want to congratulate the government for trying to get this issue finally resolved.
Yeah, we've tried several times now, and in fact, part of the response was, I think, the government has been saying this since the 1940s. You've ignored them so far. Keep ignoring them.
From my perspective, is the earlier copyright case that Tim discussed was Kurtzang, and it's really got two prongs. One is a very tight statutory analysis of the Copyright Act, and the other is the policy component, which goes to free movement of goods and English common law of movement of chattels. Now, Professor Holbrook put his money where his mouth was because you testified about that you predicted the outcome of the Federal Circuit en banc appeal in London and won that case. But I think it's going the other way, my friend. We got to have a friendly wager and about it. But again, let's see what comes.
I didn't say I did. I think you're right. I just think that would be a mistake, particularly on the domestic exhaustion regime. But I think you're probably right. Right. This isn't one where the Supreme Court's like, sure, we'll take to agree. That happens on occasion, but not often. Right. So
the other thing I'll point out is just on the international issue. One of the things we've noted in our brief is that the United States is a party to several international agreements in which we've committed, as a matter of bilateral trade agreements with other countries, that companies will be allowed to reserve their patent rights in international sales. So we point to that as part, and those are not just sort of, there are many types and flavors, as you may know, of international agreements. These were international agreements negotiated, signed, and then approved through specific public laws passed by both houses of Congress and signed by the president. So it's an odd thing to try to reconcile those sort of one-off or like very specific international agreements blessed by positive U.S. law with a common law doctrine. It's just a strange problem, but
And
A very real one.
I don't find it that hard to reconcile, right? Because it's clear that the USTR have been advocating for domestic exhaustion regimes under the copyright context, right? And to say that they can reserve the right, well, if it's domestic exhaustion, then the default is that they've reserved the right. They just have the opportunity to relinquish those rights if they so choose. So in some sense, all we're doing is we do adopt the Solicitor General's position is flipping the default around, and then we just contract define who it is. But I don't think it's irreconcilable. I just think it's which default are we talking about?
Should just be preempted as against public policy, but that's a different issue.
So earlier this morning, Professor Manel mentioned the NTB v. RIM case, the famous BlackBerry case. It's a case that didn't really affect law. It wasn't a legally significant case, but it was incredibly practically significant because the notion that the patent system could somehow loosen us from our crackberries was really disturbing and daunting, and I think really led to a lot of congressional and judicial interest in the patent system. We have another such case that's really excited the imagination, I think is moving the meter a lot. And of course, it's Samsung v. Apple. Josh, what do you think about that?
Well, fortunately, I get to talk about a different and much more fun mess here. So Apple v. Samsung, number of different issues and cases. I'll start with the 2013 jury verdict that found Samsung smartphones infringed Apple's design and utility patents in the iPhone and its user interface, and also diluted Apple's trade dress. They awarded about $1 billion in damages. I guess that's real money, and about $400 million on the designs. The designs at issue were addressed the front face, the bezel, and some of the graphical user interfaces on the display screen. In 2015, the Federal Circuit reversed the product configuration trade dress claims as functional and invalid because they're, and this is in the unregistered physical designs. I won't go into what they are, and the registered on-screen icons. They rejected challenges that the design claim construction included too much of the functional elements, rejected various challenges to awarding the entire profits of Samsung's infringing smartphones, held the utility patent double tapping, substantially centered feature was not indefinite, and one claim element wasn't inherently anticipated, and they upheld lost profit and reasonable royalty awards. Cert was granted only on the design patent damages issue. So in light of the famous carpet cases where owners of the design of surface ornamentation on a carpet were unable to prove their damages of infringing carpet designs in 1887, that's how far back this goes, predecessor to Section 289 was adopted, and that section, Congress provided that when an infringer, quote, applies the patented design or any colorable imitation thereof to any article of manufacture, it shall be liable to the owner to the extent of his total profit, but not less than $250, and the patent owner shall not twice recover the profit made for the infringement. Section 289 was clearly designed to address the difficulty of determining how much the surface ornamentation design patents had prompted sales of the product's contribution approach or apportionment approach. And there's no doubt from the legislative history that that was in mind. What wasn't in mind was product configuration designs, and as you'll hear in a second, something which is really basic. But its application in the context of product configuration and multi-component products in particular, such as a smartphone, is obviously leading to disproportionate results. It can't be that infringing the corner edge that's rounded of the smartphone should entitle you the entire profit of selling the smartphone. It just makes no sense, and that's what Congress said. So what do you do when Congress does something truly crazy that's not probably unconstitutional? That's what the Supreme Court has to face. Note that the problem was actually made much more difficult by the 1980 decision of Judge Giles Rich, who also expanded patentable subject matter by expanding design patent subject matter to authorize partial article designs. Case called application of Zahn. So now you can get, the corner of the thing being the design that you get the patent for, and now you get the profits on the entire smartphone. So at oral argument, Samsung abandoned its causation argument, the idea that you had to show that the amount of the profits are actually caused by or attributable to the design infringement, and focused on the only thing that really has any legs, which is it's limited to the article of manufacture, and the article of manufacture for these purposes can't be the entire smartphone. It makes no sense to do so. The problem is, what then is an article of manufacture? And this is an issue which no good answer was given. Supreme Court had no idea from what I read that they have any idea how to handle it. So what's going to happen? They're going to say the Federal Circuit didn't consider the possibility that the article of manufacture is selling less than the entire project. Go back and set up a whole new law of what articles of manufacture are, just like we do under 101. It'll come back to us in a few years and we'll clean it up again. That is only half of the smartphone wars. The other fun one is that in the utility patents, the Court of Appeals for the Federal Circuit on February 26th reversed a jury verdict against Apple for $120 million in damages for Apple for infringement by Samsung. And they had reversed on one of three utility patents in that case. First, they reversed one of the patents on infringement and then found two of the patents were obvious. And the majority of the Federal Circuit granted en banc rehearing, and amazingly enough, the majority did so without requiring further briefing by any of the parties, by Amici or the government. This is the first en banc obviousness case held by the Federal Circuit in 26 years. I'm pretty sure this is going to go up and that the Supreme Court is likely to take it. I won't go into the claim interpretation that was involved in the infringement. The type of utility functions were swipe to unlock and tapping and having the autocorrect suggestions appear somewhere else. The panel had found these to be obvious, notwithstanding some secondary consideration evidence. Judge Moore's opinion for Judges Newman, Laurie, O'Malley, Wallach, Chen, and Stoll, with Judge Hughes concurring without an opinion, held that the panel had relied on extra record evidence for its claim construction, and on obviousness, they did find substantial evidence support the jury's black box verdict on what was sufficiently non-obvious. The dissents in this are at best politely strident, I guess is the way I'd put it. Yeah, Judge Dyke, who wrote the panel opinion, said the following. It just warrants reading. While purporting to apply established circuit law, the majority is in fact making significant changes to the law as articulated by the Supreme Court. Indeed, as Judge Reyna convincingly points out, it's difficult to understand how this case would satisfy the requirements for en banc review if the majority's purpose were not to clarify the law. Majority states that it takes the case en banc to correct the original panel's reliance on extra record evidence. This could hardly be the reason the majority has granted en banc review, since the panel has continually expressed willingness and indeed desire to eliminate references to any extra record evidence because of concerns raised in Apple's petition, because it were unnecessary to the panel opinion. While for the most part the majority does not express its shifts in obviousness principles explicitly, an examination of the majority opinion makes clear its substantial impact on the law of obviousness. Judge Dyke goes on to identify 6 different ways that this changes the law of obviousness. First, turning legal questions of sufficiency of motivation to combine, and significance of the secondary considerations into factual rather than legal issues that therefore make it for the jury, authorizing patents on minimal or trivial innovations, finding combinations of prior art to solve known problems insufficient to render the claims obvious without further evidence of a specific motivation to combine, further restricting relevant analogous art under 103, overly emphasizing secondary consideration and failing to consider the closest prior art when evaluating the secondary consideration nexus. Judge Prost goes off on in a separate dissent on the scintilla, that basically there's only a scintilla to support the jury's finding, therefore it didn't meet the substantial evidence standard. Judge Reyna significantly says, look, this is basically a violation of our rule of law. What we're seeing here is the problem of panel dependency and majority interfering with whatever the normal processes are just to reach a different result. We shouldn't have it. So pretty harsh language, pretty strong issues, and to the extent that it does in fact change the law as it was under KSR, I think a pretty high likelihood that that will go up. At least there's going to be a petition and probably a grant.
Thoughts? Anyone?
I got nothing.
No, I was going to say on the Apple, the Supreme Court case, right? At least Samsung had something to be happy about after that argument, after a pretty brutal couple of months of exploding phones and that in-bank decision, right? But I do think it's clear that that's going back, and I do think it's getting. In fact, when both sides were in essence agreeing that it all depends on what the article manufacturer is, I thought that was a stunning concession, and
Apple,
I think
right?
there are a lot of people that were not happy with that.
Yeah. I thought my only reaction was I thought the Supreme Court might have been annoyed that nobody was defending what the Federal Circuit's rule was, right? Nobody was saying, no, the statute says you do get 100% of the profits for just the corner of the device. And by the time of the oral argument, Apple was agreeing that the question was whether what is the article of manufacture, and they were defending it on sort of case-specific grounds, that in this case it was the entire phone.
I'd actually be surprised if the Supreme Court was unhappy that no one was defending the Federal Circuit.
Usually they like to at least hear one side, all the sides. Yeah.
Deanne, could you talk about Halo v. Pulse and enhanced damages?
I can. So Halo v. Pulse was a case decided in June of 2016. As I'm sure you all know, 35 U.S.C. 284 states that quote, a court may increase the damages up to 3 times the amount found or assessed, unquote. But in its 2007 decision in Seagate, the Federal Circuit held that a plaintiff seeking enhanced damages must show that the infringement was willful under a 2-pronged inquiry. I'm sure everybody knows it, but I'll just breeze through it. First, the patent owner had to show by clear and convincing evidence that the infringer acted despite an objectively high likelihood that its actions constituted infringement of a valid patent. An objective recklessness would not be found if the accuser raised a substantial question as to the validity or non-infringement of the patent during the infringement proceedings. And second, if it could establish objective recklessness, the patent owner then had to show, again by clear and convincing evidence, that the risk of infringement was either known or so obvious that it should have been known to the accused infringer. So in Halo, the Supreme Court said no. And it concluded that that test was, quote, unduly rigid. So this is just one in a line of cases where the Supreme Court says the Federal Circuit, in the Supreme Court's view, has adopted a formulaic, rigid test not found in the statutory language and has said, let's come up with a different formulation. So according to the Supreme Court, the problem was that the prior test required a finding of objective recklessness in every case. And so the court reasoned that the language, which I read to you at the beginning, doesn't say that, and it contains no explicit limit of that sort. And the Supreme Court also reasoned that the concern with the Seagate test, in its view, was that it allowed defendants to escape enhanced damages as long as they could point to some reasonable defense that had been developed in the litigation. So the Supreme Court did hold that the decision about enhanced damages was within the discretion of the district court, but it emphasized that discretion is not whim. And it starts out its opinion with a long dissertation or discussion about the history in which enhanced damages had been awarded, and describes the kind of cases in which enhanced damages had been held to be appropriate in the past. And it emphasized that they should be limited to egregious cases of misconduct beyond typical infringement and should not be awarded in, quote, garden variety cases. So I think it's also worth noting and interesting to read Justice Breyer's concurrence, which was joined by Kennedy and Alito, and expressly said, we're joining the majority opinion because this is what we understand that to mean. Justice Breyer asked a lot of questions at the oral argument, expressing concern about not in throwing out the Seagate test, not to establish a regime that would potentially squelch innovation, especially by small companies, couldn't afford to hire a lawyer to give them advice about whether or not they were going to be infringing. And so he wrote separately to emphasize that it should be reserved for the egregious cases of deliberate or wanton conduct, citing language in the majority to that effect. He stressed that a counsel opinion should not be necessary to avoid enhanced damages, although he did note that it could be helpful. And he makes one final point that I think is worth noting about the Federal Circuit. So he says, although they also want, as part of the decision, they changed the standard review. The Federal Circuit had like a three-part standard. He said that although it's abuse of discretion, quote, "The Federal Circuit may take advantage of its own experience and expertise in patent law in deciding whether or not there had been an abuse of discretion," and he emphasized that an error of law is ipso facto an abuse of discretion. So I did look to see how this has played out. There have been a handful of cases in the Federal Circuit, many of them that were, either remanded from the Supreme Court after the decision in Halo or decided by the Federal Circuit after the decision in Halo. And more often than not, right, at least at this point, they're sort of remanding for the district court to take another whack at it under the new tests. So it's too soon, I think, to see how this is going to play out.
I'll just add two things. The first is I think that this unfortunately furthers the mistake in Comel because it doesn't actually require that the alleged infringer understand that their act is violating someone's rights in order to find egregious conduct. And the second is that it's an interesting question now whether or not continuing infringement during appeal should now be found to be egregious.
I thought it was one of the first times the Supreme Court said something nice to the Federal Circuit in a really long time. So I think ours is kind of interesting.
We had a footnote in our brief in that case in which because we thought the case had all the hallmarks of a complete reversal of the Federal Circuit. What are you doing? None of this is in the statute, just as Deanne said. And I thought it was important for us to recognize that the court had adopted the Seagate test in response to the sort of cottage industry of expert opinions and infringement opinions in the 1990s. And in fact, I forget the name of the particular underwater devices or something, right? That it basically required it in order to avoid enhanced damages. And a lot of that problem was taken out by Section 289 of the AIA, which now says that the failure to obtain or provide an opinion of counsel shall not be used as evidence of willfulness. So it seemed fair to change the standard, but it also seemed important to acknowledge that the Federal Circuit had been reacting to a real problem in the world when it adopted the test that it did.
Team was an odd case because it's just a replay of Octane Fitness with respect to attorney fees a few years earlier, and you wonder why the Federal Circuit didn't get around to adjusting its own willful infringement law. To me, it's also interesting in the Hatch-Waxman context because courts have traditionally held that copying of brand name pharmaceuticals is something that Congress has encouraged, and as a result, generics don't have to face willful infringement liability when they do so. This sort of sets the bar a lot lower for willful infringement damages, and we'll see what comes. Well, I got the 5 minutes. I thought we could go on to the original deadline, but I guess not. So we're going to go over a little bit more. Professor Holberg, you got the last case then. Let's do Life Tech.
Let's do Life Tech. All right. So Life Tech versus Promega is up at the Supreme Court now. It is the second case the Supreme Court has taken in recent history on Section 271F. Why they care, I think many people wonder. My theory is that it's actually part of their broader agenda addressing extraterritoriality in U.S. law, period, right? So the Supreme Court doesn't think about this as a patent case. It thinks about it as an extraterritoriality case. And so for those of you who don't know, Section 271F defines infringement as exporting either all of the components of the patented invention with the intent that they be, where you induce the assembly abroad, or 271F2 is where you export a single component with no substantial non-infringing use, also with the hope that it be assembled abroad. This case is specific to 271F1. What the invention is a kit for identifying repeat sequences in DNA. So it's a DNA fingerprint, to be really, really 30,000 feet level about it. What the infringer was exporting was simply Taq polymerase, which is actually pretty standard. It's not anything that's really unique. And then that polymerase is incorporated into the kits abroad. And so the question, but this is the 271F1 issue, right? This is not contributory infringement or under F2. Why? Because Taq polymerase has substantial non-infringing uses. And so the court addressed two issues at the Federal Circuit. One, whether an entity could induce themselves under the provision to infringe, or whether inducement required a third party. The Federal Circuit panel said, yes, you can induce yourself. Chief Judge Prost had dissented on that ground, and she was commenting earlier. She's like, I dissented on the wrong point. I should have gone to the second point. Why? Supreme Court didn't take that issue, right? The only issue they took was the second one, is whether a single component can constitute a substantial portion of the claimed invention. And here the Federal Circuit said, yes, the Taq polymerase is a substantial portion of the claimed invention, and there is liability under 271F1. From an extraterritoriality perspective, that's an expansive interpretation, that now more things are ensnared by Section 271F1, and you no longer have the safe harbor of Section 271F2, that the component have no substantial non-infringing uses, right? So this interpretation risks swallowing 271F2 and that important safe harbor. So from that perspective, it's not surprising the court took it. The argument is going to be on Tuesday. Full disclosure, I wrote an amicus brief in this, and it's to me clear that this is going to go the other way, that basically you're not going to be able to have a substantial portion of the claimed invention being one component. Whether they do any more line drawing than that or not, and how much they rail against the Federal Circuit for not following the presumption against extraterritoriality remains to be seen. I think that the court at best has been inconsistent in its application of the presumption, and so this may be a chance for the court to tell the Federal Circuit, no, we mean it. When we said in Microsoft versus AT&T that the presumption has particular force in patent law, we really meant it, so please apply it.
Closing observations from anyone about any other cases?
I just have to say, I don't think we can close out a year in review of patent law without saying something about Quozo, the Quozo versus Lee case. And the only thing I'll say about it, you've probably all seen it, and it's gotten a lot of attention for the reviewability issue, what is final and non-appealable. What I think is remarkable about this case, and very important, and probably more prospectively important than that issue, is the utter unanimity and unremarkability of the Chevron analysis. Basically, the Supreme Court was unanimous on, of course, this is a Chevron question. The statute doesn't speak to it. The agency has in the AIA grant of rulemaking authority to adopt rules establishing and governing inter partes review. And so statute doesn't speak to it. We can issue a rule. They issued a rule. Rule is reasonable. End of story. 9-0. I think for many patent lawyers, it was probably a small, like, like the idea that the PTO can exercise all the traditional powers of an executive agency in rulemaking is pretty new in some circles, and in particularly remarkable was the passage in the opinion that said, because some of the arguments on the other side had said, no, the Patent Office can only regulate procedural rules. It's only procedural power, citing a series of cases interpreting a different rulemaking authority of the Patent Office. And we had said some things about that in our brief, but the Supreme Court just says, whatever the circuit's claimed limitation on that other rulemaking authority is, it doesn't apply to this statute. And that, I think, is a pretty robust endorsement of the agency's rulemaking authority, and I think we can expect to see citations to it in the future.
All right, well, friends, please join me in thanking the panelists for our panel. Well, we're over for today, but do we have a reception after this, or we have any drink? And where is it? Where is it? Okay, to guide us. Okay, but before we go, I'm going to show a bit for tomorrow's event for just 1 minute. We're going to have more data presentation from RPX. Emily Ransom is here to, I'm sorry, Emily Hostage is here to, I'm really getting quite a bit older, aren't I? So as it has going to drill, if you like patent data, this is the place to be tomorrow. Okay, it's going to start at 9 a.m. We'll have some breakfast for you before, and then we're going to have 2 panels on patent damages. So if this is an area of interest to you, please join us tomorrow. We look forward to seeing you. And I'll see you at the reception in a few minutes. Thank you again. One more time.